And with that, let me just introduce Loris Morella, who's going to serve as our moderator for today's event. It's with particular pride, I think, that we get to introduce Loris. Loris is a deputy director at what is now called Global Affairs Canada. It used to be called DFAE. He's been there for the last 6 years working on trade negotiations and intellectual property. Before that, he spent nearly a decade at Canadian Heritage focusing on copyright policy, and he was the lead Canadian negotiator on the intellectual property chapter within the TPP, and so he is ideally suited, indeed, I don't think there's anybody better suited to talk about these issues than Loris. But the pride and excitement of having him participate in this way extends beyond the fact that he is so perfectly suited to the role. The first is to note that the mere fact that a senior government official is willing to come and participate in this event is, I think, an amazing change. Frankly, we didn't bother asking anyone for roughly the last 10 years when it came to these kind of events, because we sort of knew the answer in advance. We asked and weren't sure what the answer would be, and when the answer came back that Loris would be happy to do it, we were thrilled, but I think it's also a really great signal about the openness generally within the government and the openness, frankly, to talk about some of these issues, which is good. The other reason that we're really thrilled to have Loris here is that we claim him as one of ours. As Loris is a graduate of a number of universities, but the one I would focus on would be the University of Ottawa, where he is a graduate from our LLM in Law and Technology from a number of years ago, and so it is great to see our grads come here and then succeed and have such an impact in the way that Loris has been having. And so with that,
Thank you, Michael. That's great to be back. The only thing I would quibble with is the senior government official part. That's senior, it's relative. It is a great pleasure to be here. I'm very happy to come and speak about these issues. It's great going through the Law and Technology program to be here and talking about technology and trade issues. So I think that's going to be a very interesting topic to parse out today. I just want to say a couple of words then, just given that it's been a while since we've done this kind of thing, I guess. It's great to have this opportunity to participate in an event like this, which will really, I hope, enrich everyone's understanding of the issues involved. The negotiations ended on October the 5th, as everyone knows, and the new government was elected on October the 19th, and so it's a very interesting relationship. The agreement was concluded before the new government came to power. And I think the government has been very clear, and I know Minister Freeland, my Minister of International Trade, has been very clear that the government would like to consult Canadians on the TPP, what people think about it. They want to understand better what the TPP means across all the sectors of the economy and how it impacts on society, civil society, business, etc. And I think this forum is going to contribute to that once I shut up. So I think in that context, my role, if I can contribute anything, answering questions or providing some information about the IP chapter, I'd be very happy to do that. The broad theme that we're going to talk about today is IP and technology, and I think there's quite a few chapters. I think it's a good way to approach the topic, and I think it cuts across a number of the chapters, which are divided, intellectual property, investment, e-commerce, etc. But taking a theme like technology cuts across a lot of those. So I think we're going to have an opportunity to dissect the agreement and to hear more about it in interesting ways. So some of the themes that we're going to talk about have to do with, for example, anything where technology plays a part in business or social endeavor. So, for example, in biotechnology, in relation to e-commerce, in relation to copyright, in relation to telecommunications, trade secrets are a big component as well. We're also going to talk about internet governance. We'll talk a little bit about ISDS and enforcement. These are all possible themes, and if there's any other themes that people feel need to be covered, we're happy to do that as well. So let me turn quickly to introduce back the people who are going to be talking about these issues. I have a long, the speakers are incredible, and the bios are so long, but I think I'm going to do the abbreviated version so we could spend more time talking about the issues. So let me just introduce them in the order that I have them here. First, let me introduce Jeremy de Beer, who's a tenured full professor of law here at the university's Center for Law, Technology and Society, where he researches technology, innovation, intellectual property, and global trade and development. Jeremy de Beer. And next, let me turn now and introduce Michael Geist, who is a full professor of law at the university here, where he holds the Canadian Research Chair in Internet and E-commerce Law. And I don't think I need to tell you more than that about him. Next, let me introduce Tamir Israel, who's the staff lawyer at CIPIC, the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic, where he conducts research and advocacy on various digital rights-related issues with a focus on online privacy and anonymity, net neutrality, IP, intermediary liability, electronic surveillance, spam, e-commerce, and internet governance.
And trade.
Especially rabbits, right? And then our two out-of-town guests who are here, traveled a long way. Thank you so much for coming, making the trip from Washington. First, Virtue Killick, who is the Legal and Policy Director at Public Citizens Global Access to Medicines Program. She's an expert, and I can attest to that because I've had a lot of discussions with her on these issues, on legal, economic, and political issues surrounding IP law and policy, trade, development, and innovation. So welcome, Virtue. And also let me introduce Carolina Rossini, who is the Vice President for International Rights and Strategy at Public Knowledge. Previously, Carolina was the project director at the New America Foundation's Open Technology Institute, the International Intellectual Property Director at the Electronic Frontier Foundation, and a fellow at the Berkman Center at Harvard University. And I think you get the sense probably of what those are, but if anyone wants to add a little bit about other things in their background, that would be great. So that's by way of introduction. I had one question that I wanted to present to the panelists, and we could do it maybe picking up on some of the themes that I mentioned there, or we can start from questions. But the first question I had, since we're starting with specific intersections between trade and specific topics like biotechnology or copyright, it would be very interesting from my perspective to hear a bit more generally how technology and trade intersect. How does trade impact on technology? Because, what do we think about when we think about technology in that regard? So maybe that would be a good place to start, and then we can dive into the specifics of these different themes. So with that, I invite the panelists to maybe address that question before they start on one of the other themes.
Sure, thank you. So thank you everybody to be here, and thank you so much, Lori, for the introductions, and Mike and Amir and everybody for the invitation. It's always good to be here with you guys. And I think it's fair to say that for all of us, this is a hard, tough issue to grab on. It's 6,000 pages of a trade agreement, and it was a challenge that was set by the negotiators of more than 12 countries now, to really develop something they call a 21st trade agreement. And for that, you can define that however you want. That's actually a pretty hard, because depends on what do you want for you as a citizen of a certain country, of what 21st century represents. But said that, it's 30 chapters, lots of footnotes, and lots of bilaterals, which means that each country will have not to just look at the agreement as a whole, but also on how that how a certain language apply to their reality specifically. And it's not just only those countries involved. It's actually every country in the world, because there are rumors that is going to be deposited in the WTO. It has to be deposited for notice anyway, but that countries could sign on then into the TPP and assume that, which actually might be good if you want to think about technology and interoperability and free flow of information and freedom of expression and things like that. And it's fair to say that we have a gigantic impact on what we call internet governance, or the governance of technology as a whole. Burju and I and many Michael guys here, we have been trying to alert the internet governance community, which is a separate community from the trade community, saying this is relevant. We have mapped 10 years of trade agreements that US have been leading, and all of them have some language that's impacting what we call the internet layers. I will not enter in medicine, that's Bourdieu's space. So from infrastructure to what we call the social layer, if you adopt Zittrain's model layers, Zittrain from Berkman, you have something there. And it's amazing that you cannot look just one chapter. You have to look at least on 4 or 5 chapters. So you have to look at the e-commerce chapter. Those are the basic ones. The e-commerce chapter, the IP chapter, the service chapters, the telco chapters. And if you want to understand how those actually apply, you're going to have to start then looking to other of the chapters, such as the enforcement chapter, the investment chapter, the dispute settlement chapter, and the regulatory coherence chapter. So you're going to have a lot of language to digest, and the important thing in trade agreements is to understand what each verb and comma mean, because they may mean obligatory things, or they may mean exception, or they may mean actually suggestion or a voluntary regulation. So it's actually, I love it, it's fun, but it's hard. So, and I think, so some examples, and then I leave for my colleagues. So you have things from universal access to internet. So if you think a lot of countries developing their broadband plans, so you have some provisions on that, to intellectual property, as Laurie mentioned, on terms of balance and exceptions and ISP liability, to even privacy. You have consumer privacy there, you have data flows there, you have server placement there. It was very interesting that weeks later that the TPP was then approved, Germany came out saying we're going to have localization of servers in our country. So we are living in a very interesting moment, and it's not. I think it's very simplistic if we say this is good or this is bad. So we have to be very careful there moving forward. So the language, our own interpretations don't bite us later. As an advocate for the public interest, we have to be very careful, because if we say this, say X, and that X is very good for human rights, that may be, that's the language a judge is going to use later, so that bites us later. So we have to be very careful on how we are reading the language right now.
I would just note, just to pick up on the theme of tech and trade, or trade agreements. I mean, in some ways it's interesting, because it's the sort of question that if we were thinking about trade agreements and free trade agreements years ago, probably wouldn't even come up as a question, right? For those that remember the battles over free trade agreements here in Canada, let's say the Canada-US free trade agreement, many of the kinds of provisions that we find in this sort of agreement just simply didn't exist in those sorts of agreements. And so we've seen several generations, in a sense, of evolution of these kinds of deals, starting first with the strong emphasis, particularly out of the United States, for including intellectual property in those agreements. I don't know, when you moved over to DFATE or Global Affairs, I don't know if a decade earlier that was the kind of position that they even focused on, because for the most part, there was very little by way of intellectual property there that would have been placed have an influence on tech. If we look at what the TPP does, it takes us yet another generation forward. And Carolina highlights some of that as it starts moving into areas such as privacy and internet governance, and where data flows can go. And so when we talk about a trade agreement, especially in Canada, there's been a lot of talk about dairy and the automotive sector. I mean, the kinds of things people can readily understand, and I think typically think of when they think of trade agreements. Say, okay, well, we've got tariffs, or in some instances quotas, or other sorts of government assistance, and the trade agreement is designed to facilitate greater flows of those kinds of products. This isn't your parents' trade agreement. This is a trade agreement that really goes to the heart of what our economy is going to look like for decades to come. Because the kinds of provisions that we were debating in earlier trade agreements are really a very small slice of that overall 6,000 pages.
Can I just pick up on that for 1 second? Because I think Michael's absolutely right. When the regulations required to implement these kinds of trade agreements go behind the border, so to speak, there are profound implications. And I think it's worth reminding ourselves that the very existence of intellectual property provisions in a trade agreement is itself very controversial. On one theory, the harmonization of intellectual property standards across jurisdictions is supposed to encourage trade and foreign investment. But my office is full of books showing how empirically that's not the case. And so it's still very controversial and uncertain whether intellectual property, in particular its relationship with technology and technology innovation, enables or restrains trade. And so I think it's really important that we don't get ahead of ourselves in the debate to start thinking about, well, what exactly should the provisions look like? There's still like a fundamental question here about whether chapters like this belong in these kinds of agreements.
So with that started, oh, sorry. Tim.
Oh, I don't know. So do you want to? I was going to add quickly on top of all that. Yeah, so I think one of the interesting things that's happening with trade agreements is that they're definitely, as Michael and Caroline were saying, they're expanding its scope to swallow up these other areas of the law. Intellectual property was the first kind of big chunk of that had a large technology component to it. And now we're seeing more and more enter into that, including privacy, net neutrality, and telecom also actually came in early, but is expanding. And then one of the issues with technology in particular is that because it's such a rapidly evolving medium, being locked into a very specific regime at the trade level it can have unintended consequences 5 years down the road. Because whereas a domestic framework is easy to amend and change to roll with the rapid changes that happen in technology, trade is a little bit more difficult. So this round, I think, was still fairly high level in terms of the specifics of the requirements that they impose, but with the generational shift is not just one that keeps including other topics, but it's also getting increasingly more specific in what's in the requirements, which could also be a problem in the tech context down the road.
And I want to add something on that, because when we talk about trade agreements, and I'm just looking into a photo here, like what I don't think anyone, like everyone can see that. When TPP came out, it was released, we printed it. We wanted to measure, like it's 13.5 inch tall. Like we are talking about 6,400 pages, excluding the side letters, and 30 chapters. So this is a trade agreement, so like let's visualize that. And interestingly, I was in Geneva in July doing some WTO work, and I was talking to people in Geneva, and they told me something very interesting. If you want to get things done, you need to go through trade agreements, because apparently in multilateral fora, not much is happening because of like all the power balances and developing countries becoming like stronger and stronger, becoming better negotiators. So the trade route is the route that you should take if you want to get things done. But when you are getting things done, you are getting things done for who? We talk about technology. I'm a patent lawyer. I deal with technology, and when I read the TPP's IP chapter, because when we talk about IP chapter, it's like it's great for innovation, and I'm like, no, because the provisions are drafted in a way to keep existing monopolies, not to extend them. Like the knowledge doesn't build on the shoulders of giants. The knowledge stands with the monopolies. So that was all the criticism when we've been doing the TPP. Like I was stalking them like last 4 years, every TPP round, like trying to chase them at the corridors. But that's what I was reading. Guys, let's talk about innovation. But this is not innovation. This is the old system. The IP chapter, we can talk about that, but it's the 20th century chapter. The rules are 20th century rules. And we talk about the 21st century, we talk about open knowledge, open economy, open everything, but closed door negotiations. And with this very traditional conservative provisions on intellectual property.
If I can refer to that, I think that's a very important point to make, and the same happened with the DMCA, like the copyright and ISP liability regulation law in the US. We call that forum shifting, right? So if you go to a place where countries, developing countries and developed countries have one vote each with the same weight, which is the case of the WIPO, World Intellectual Property Organization, and WTO, the World Trade Organization, it's much harder to get consensus. And if you have at all follow what happened in WIPO, developing countries actually got a lot in the past 10 years. I'm from Brazil originally, we got the development agenda, we got the Marrakesh Treaty for the blind, and now nobody believes it's gonna come through, but there is the exceptional limitations for education and for libraries. The education, they think never is gonna happen, but the libraries, it's moving slowly, but it's moving. Maybe we're gonna have some trade-offs there with the broadcasting treaty, which is not another good thing. But the point is when countries, and the same happens with internet governance, right? You don't have one-to-one. In the WSIS, for example, in the WSIS process that's happening right now in New York, the General Assembly is gonna be in December. They don't wanna hear about tech transfer, right? They don't wanna hear about this sharing knowledge internationally. So they didn't even wanna bring access to information to the WSIS review agenda. And because they were actually negotiating that in trade agreements where Peru needs access to their minerals, to mineral market, to sell their minerals, and they were giving up intellectual property provisions. And I was talking to a negotiator in one of the rounds I say, but do you understand that this is what's gonna happen with the service and internet economy, and this is what's gonna happen with the mineral economy, and we are actually cutting the option of your youth to innovate with some of the provisions. That were the very bad provisions in some of the first rounds. Those provisions have changed. All that fear of soap and pipa, that is not there anymore, but there are still things to think about it. But it is a power, it's an easier trade-off for developed countries to negotiate those things in trade agreements. So it's a reality and has been since after TRIPS.
We don't have any set, there's a question. There's a few questions. Well, how about we take a bunch of questions, and since we're covering all the topics at the same time, let's take a bunch of questions and then we can address them then all together. So, okay, Howard.
Welcome, Morris. I'm glad that you are where you are and that they've let you out to play. And so
Lights are a bit bright, though.
Pardon?
Lights are a bit bright.
So I got a really simple question for you, and don't mean to put you on the spot or anything, but given that all of this was done under a caretaker government that tweaked a little bit the normal convention, which Michael has eloquently pointed out, and given that things appear to be anything but certain in the United States with regard to the future of the TPP, my simple question is, what realistic chance is there to tweak or revisit certain issues before we get married to it, as it were, through ratification? And for the panel, when you come to it, you know, if you tell us that there is some realistic possibility of making it better, and not just talking about it forever as a past done deal, if it can be revisited in any way, I'd love to hear from the panelists, and you, to the extent you can talk about it, what issues we might focus on, such as ISDS or whatever. You know.
Okay, I think that's a process question which we'll put in the mix as something maybe we'll want to come back to at the end just to answer anything on those. But let's get a bunch of questions right now.
Hi, I want to ask, somebody spoke about the existing TPP provisions defending existing monopolies, not actually supporting innovation. What provisions, would you give us an example of the type of provisions you feel will practically support innovation in the Canadian context or the developing country context? What are the provisions that would support innovation? And what are those that do not?
That's good, and I think I saw a couple more.
I have a couple of questions. One is, which are the main provisions that harm human rights in this context, that affect the internet mainly. And the other one is what countries, especially developing countries, can do now that the TPP is finished. If there is any way for some flexibility in the implementation, if there are any next steps. For instance, what happens if a country like the United States have to negotiate a future trade agreement with another country, and they get better flexibility, wording text in the future that is better for civil society in the text. There's any way that you can change the TPP to try to get this better implementation in a future trade agreement, or what's the steps that country can do right now to try to get this better future implementation?
I think a couple more.
Hey, so Don and I, we're at Policy Horizons Canada, and we're trying to figure out challenges and opportunities facing the future of Canada for 15 years out is their typical window. Obviously, the future of technology is pretty important 15 years out for Canada's welfare. We were at the Ottawa Economics chapter where they had a debate on Thursday about the TPP. I asked them a question, which was that one of the participants suggested that Canada should do a sector-by-sector cost-benefit analysis of TPP before we commit to ratification. That was sort of like thought to be generally a pretty good idea. So the way I think of the TPP is sort of informed by Krugman and Stiglitz's position, which is kind of its three layers, right? There's a trade barrier layer, there's an IP layer, and there's an ISDS layer. And you could argue there's also rules of the road around, at least this is the way the US has sold it. It's sold around the notion of better environmental and social rules. That's sort of the idea, labor rules particularly. Does the panel know of any way that you could do cost-benefit analysis outside of that first layer on behalf of the IP layer or ISDS moving forward? That would be of great interest to us.
That's awesome more.
Yeah, so I have two questions. First, is there anything that's novel in the TPP's application of ISDS to the IP chapter compared to NAFTA or other previous trade agreements? And then second, which is very specific, I'm curious how, I've been researching this, how the TPP treats internet retransmission of broadcasted content and how that differs from Canada's regulation of this issue.
Extra point for your questions.
She's handing you off one of our research questions that we gave her to do.
You put her under the bus.
That's good though, it'll benefit the public.
I just wanted to do a far less general question, or a more general question. Just about it seems that what's been emphasized already is that this is an enormous trade deal. And it seems to mix baby with bathwater, but it seems also, we've been given, my understanding is that it's supposed to be either like, basically get a thumbs up or thumbs down in its entirety, and that's the end of it. I just wanted to ask, like, why isn't this many trade deals instead? And what's the idea behind gluing all that stuff together? When it sounds a lot like it, a lot of it is pretty strange to fellows anyway.
And I think one more, and then we'll.
Oh, that's a lot.
Wait, that's too many?
We'll try to.
Okay.
I would love it if someone would touch on the data localization aspect, because I can see actually potential for harm. If you're allowed to do, if you decide to do a data localization in opposition to what the trade agreement is saying, if you do that badly, that could be more harm than good. And there's a potential to do it properly.
Okay, Okay, thank you. And so with that, we have a broad range of questions here, everything from governance to specific issues. So I don't know, maybe we should start with the last question first. That's a very specific one, and we can move.
You're gonna contradict me. Yeah. So I mean, the data localization. So again, part of the I'm going to throw in some process stuff as well. I mean, part of the process of the way that these trade agreements are developed is because they are negotiated without the text being public. The people the commentary is not always in line with what ends up in the agreement, and it's not always in line with what ends up at different parts of the agreement. So iterations of the data localization requirement were very rigid and would not have allowed any data localization at all. And also, at least in the way that they were presented to the public, they would also have applied to public procurement, which means that the government would not be allowed to localize any data whenever they're applying for a service. I think those are two issues where we're kind of heightened levels of concern, or out of recognition that there are some contexts where data localization is important for highly sensitive data, health, people's health information. There's a particular NSA issue like that comes up a lot, which I can get into for like an hour and a half, but I won't. So I think at the end of the day, the point is, there is a legitimate scope for some level of data localization. The provision in the TPP at the end is not as bad as it looked to begin with. It's still fairly rigid, we think, just because the amount of justification that's placed on anyone hoping to deviate from the data localization requirement is fairly rigid. So that's one of the ongoing concerns with it as framed. But it's a lot better than it was initially. It doesn't apply to government. It doesn't apply to. It's not a categorical prohibition. So I don't know if that helps on that.
Yeah, and coming up to that provision, that was like a particular concern for us. Like that provision also works with the cross-border data transfers provision, and those are the two novelties of the TPP e-commerce chapter, which has never been leaked. So we just saw the chapter when it was released, and there's an exception language which we're still trying to understand which comes from GATS 14 language, is the typical trade exception language, and there is a huge jurisprudence out there in the WTO about that exception, and we've been having this discussion how to interpret that, and it's really hard, I have to say, because when you read the exception, it's like, great, legitimate public policy measures, but what is legitimate? And there is like a huge case law out there, and we have to figure out, so it's harder for us to say whether it's good or bad, at least the exception language. And the criticism we made was like, yeah, this is WTO plus obligation. Why are we using the WTO exception which comes from GATS like 1940s? Why can't we come up with a better exception which can accommodate or privacy concern or individual liberties? That's why we have to have that discussion outside of the trade negotiations and discuss what is the best exception for us, because no one is against the cross-border data transfers. That's the reality of the technology. But we have to protect our individual liberties or privacy, and we have to make sure that it is accommodated in that text.
Yeah, I think that actually, so the articles we are talking here are the 14.7, 14.8, and 14.13. So it's in commerce chapter. Maybe there is something else in the, yeah. And I think the conclusion here is that we actually, the fact that we don't know means that countries are open to fight what's better for them, right? So I think that in the process side, for example, Australia has an exception on health data, right? So they want to keep, I think it was Australia, right?
Yeah.
Yeah. So they want to keep health data in Australia. They will not authorize cross-border, which for some people might be good, but for some other people doing science innovation might be actually bad, because you don't have big samples for clinical trial and understanding of how a disease evolved. So the population of Australians will not benefit from that. So there are all pros and cons in both sides, and then countries do have to develop what public interest and legitimate interest means for them. And it's true, there is a case law, A colleague of mine and we wrote a paper about it. I can tweet about it later. It was 2011. Because our concern was that there would be actually a national security and a really bad privacy exception, but that language changed. So it changed a lot from the past trade agreement, which was Chorus, the US, South Korea, to this one. The language changed like 1,000%. So we still are trying to understand what that language means, because there are a lot of negatives. It's very funny how a lot of the text was written in double negative language. So that's very tricky.
More make work for Laura. Yeah.
I was gonna say, so there's good news, I guess. So I offer a more pessimistic view on the uncertainty, the notion that a country is open to choose, and so that expands the scope of the provision. I actually think that Canada's historical experience with flexible treaty language in some of these kinds of tech areas actually tells us exactly the opposite lesson. I think, for example, of the WIPO Internet treaties and the anti-circumvention rules from the mid-90s, which were crafted in a flexible manner, that the way that they were able to achieve consensus at WIPO on what are often referred to as the digital lock rules was to create very broad, flexible language that was open to each country to interpret in the way they wanted. And for anyone who has followed this area, and more than a decade of pressure from the United States on Canada through the Special 301 watch list and other forms of pressure, knows that in fact what happens is the day after your largest trading partner decides what their interpretation is, they will make every effort to ensure that that's the interpretation that everybody else has to adopt. And so far from being flexible, it's in many ways the precise opposite. In fact, one of the things that TPP does is seek to entrench the U.S.'s approach on anti-circumvention. So they lost in the 1990s in Geneva on WIPO in terms of a far more flexible approach, and have spent now decades trying to get back what they had hoped to achieve. This is a long game for countries like that. And so for a country like Canada, or for many of the other countries that are smaller players in the TPP, relatively speaking, that may have specific interests that they want to protect, if it doesn't say it in the language, you're going to spend literally decades playing defense until the next treaty comes along and suddenly you give up on it because, well, it's one of those things you have to give up.
Let me just add to that, since that was a response to me. And I think actually, Mike, I agree with you, because what happens is not happening just at the paper of trade agreement. If you see actually what happened is not just the 301. I don't know if you guys follow the WIPO trainings around the world. What WIPO does and US does through bilaterals that are also not public many times, they actually send their public policy, the policymakers, and a lot of their companies. So AT&T has a training for our policymakers. Verizon has a training to policymakers. I saw those guys. They have nice pictures with a lot of policymakers from Africa. And if you read the American Chamber of Commerce, it gives me like goosebumps, because actually if you read some of those things, there is a lot of wrong things. In Brazil, American Chamber of Commerce was going to actually high school classes and doing like this fun plays and rap theater with the kids, saying that there was not exceptional limitations to copyright in Brazil. So it was actually purely wrong. You know, so it's true, it's not just the language, it's actually what people do to train policymakers from developing countries on how to use and interpret and apply.
Those are both really pessimistic views, but I actually think the problem is worse. And the reason is because you're right. So all of these question marks are what we call constructive ambiguities. So you leave a constructive ambiguity, people can think it means whatever they want, and then we can agree on a text and move forward. And then you have various government-to-government pressures that get countries, when they're actually at the implementation stage, I'll talk about that in a second, to implement it in a particular way. And then you have these sort of soft norm setting procedures through training and capacity building, or what the international organizations call technical assistance, that support you to implement a particular vision. But what's worse about it is that to the extent that you think you're availing yourself of a constructive ambiguity, you can actually get sued by a multinational company from a foreign member state. And this is exactly what's happening with the Eli Lilly case in Canada, where international law is crystal clear that there is no specific standard for what constitutes utility in patent law, what a useful invention is or capable of industrial application. So Canadian courts have developed a body of jurisprudence interpreting that in Canada, and we are now being dragged before a NAFTA tribunal, being sued for $500 million with a B dollars by an Indianapolis-based company. So I think that's terrible.
Yeah, I mean, I have to add something about, because you talk about that already, and I'm obsessed with that case. Since I'm a patent lawyer, I do patent law and policy. I've been following the TRIPS and everything. Like, so when that case came out, like when I first read the notice of intent, I was like, ridiculous. Like, you know, who wrote this brief? Like, and why people is taking this company seriously? Like, and we had like many back and forth with the allied representatives, and I remember like this was like when they filed the first notice of intent in 2012. Yeah, it was like early 2013, and I was like talking to one of the representatives. I was like, what are you trying to do? Like, you will lose this case. You know, this is we have the flexibilities in TRIPS and in NAFTA that this is, I mean, no one can claim this. And he was like, look, we are not happy what Canada has, Canadian standard, the interpretation of utility or usefulness in Canada. And our concern is other countries adopting the similar standard as Canada. So this is more like a warning. This is not about Canada. This is about other countries. And I work on the ground. I work with developing countries. And how hard it is, like, to get things done, like to use the TRIPS flexibilities, which are there. Everyone acknowledges. But the country, when it comes to implementing them, countries have concerns because there is this pressure coming from the governments and also coming from the companies. And so it's the reality, and these trade agreements make it worse. And coming back to that GATS exception, the data localization exception, just one thing: the GATS and GATT exception, the countries tried to use those exceptions for 44 times at WTO, and it failed in 43 times. Only once they managed to pass all the sub-tests. So the language is there. It sounds good. But in practice, it's so hard to implement it and to prove that it's like a legitimate public policy measure.
Can I just pick up on your point about the U.S. wanting to ensure, or Eli Lilly wanting to ensure that the Canadian example doesn't spread elsewhere? Because we have a very real example of that. There are multiple examples, but to highlight one within the TPP, and to link back to the question of, well, what would you do for innovation? And one of the points that I've been trying to make, I've done a couple of posts and talks about this, calling the TPP a digital policy failure from a Canadian perspective. And one of the reasons is that I think we've done actually a pretty good job over the last number of years of crafting some so-called made-in-Canada type solutions on some copyright issues and some digital policy issues. We've got pretty good net neutrality rules, for example. We've got pretty good rules when it comes to internet providers in our notice and notice system. And one of the objectives of the United States in particular on this was clearly to ensure that Canadian policy doesn't spread. And so to give you an example of how the notice and notice rules work, it was also clearly a goal of Canadian negotiators to ensure that the existing notice and notice rules, these are the rules that were established in the 2012 copyright reforms, that are pretty good in trying to strike a balance, although they've been misused, pretty good about trying to strike a balance between the privacy rights of users and the rights of rights holders to send along notifications, and for ISPs standing in the middle to be able to qualify for a safe harbor. And the U.S. wants everyone to adopt notice and takedown. The Canadian government quite clearly wanted to ensure that notice and notice survived. There was a lot of political capital that went into that. So much so that when you read through the text, it's clear that that issue more than any other was the one that needed to survive. So copyright term extension, well, not only will we lose on that, but New Zealand will seek a delay in their term extension. Canada won't bother. We want to ensure that we keep notice and notice. So the U.S. ultimately says, okay. But when you read the text, what it does is tell you that you've got notice and notice, but the only countries that qualify are those that have a system that is described at the moment when they had agreement in principle, not even signing. So signing will presumably take place in February. It's not even the signing. It's actually back in Atlanta a couple of months ago. So if you didn't have those rules in place at that point in time, you're out. Well, guess what? The only country that qualified was Canada. And so I mean, at a certain level, that's not bad. Canada gets to keep its notice and notice rules. But in a broader perspective, if you're talking about how do you take innovation policies, you get Canadian businesses that adapt themselves to a notice and notice system. There's no ability to take that to other TPP countries because those other countries can't have that system. In fact, if you want to take Canada to be a policy leader on a global stage and adopt things like notice and notice or user-generated content, or the range of other things that we have done that are quite innovative, what the TPP seeks to do is actually box in those rules and stop other TPP countries from being able to adopt them.
Can I talk a little bit about the what next questions? The big issue is what next. It's implementation, and I think this ties back to the data localization issue as well, because there are many countries, and Canada is a great example of one, where the federal government may not have the power, the constitutional power, to implement all of the promises that it has actually made. In Canada, which is a federal system, the division of powers says there are certain things that the provinces have to do, and there are certain things that the federal government has to do. This is one of the reasons why before the European Union would even sit down and negotiate with us over the Comprehensive Economic and Trade Agreement, they made sure all the provinces were at the table. Because we were latecomers to the TPP and the process was already set, that wasn't the same kind of requirement. So now you have some provinces, like British Columbia is a good example, that has legislation which may run afoul of these TPP provisions, and that's setting up an inevitable challenge or an inevitable conflict when the federal government says, oh, we're going to do, you know, this new thing, and it prevents or prohibits or preempts, to use the US language, local governments from doing something that may be more suitable. And there are examples across the range of fields of technology. Data protection for clinical trial data in the pharmaceutical context is a good example. Trade secret law is also a very good example. This is well established as a matter of provincial jurisdiction, but there are provisions buried in the enforcement chapter of the enforcement subchapter of the IP chapter that now require or seem to require federally coordinated action.
I mean, even in the US, it's not like they don't have the... I mean, that's the problem with the trade secret provision, which not many people paid attention, you know, because we were focusing on other issues like ISP liability, biologics protection, and other issues. Yep. But the trade secret provision is very interesting because I know that there were like the negotiators said back and forth, and it changed a lot. Yep. That provision. But the thing is, like for us, like even in the US, trade secret was like a civil law matter, you know? Now with the TPP, trade secrets is becoming like becoming a criminal law measure, and the countries are bound to introduce criminal law measures for the trade secret infringement. Yep. Did we have a discussion? What is trade secret? Like, you know, so those are the issues, but we missed that point because we had to focus on other issues which were like more priority for us. And when the text came out, now we are like, okay, we have a criminal enforcement measures system for trade secrets. We can't even agree on the definition of trade secrets because TRIPS doesn't use the word trade secret, you know? It's undisclosed information because when the parties were negotiating TRIPS agreement, they didn't want to use the trade secrets because every legal system have different definitions.
Just while we're on this topic, this is really important. It's a great example of policy laundering. Yeah. Carolina mentioned the Digital Millennium Copyright Act, the DMCA. Well, there were efforts in the early 1990s in the United States to get a Digital Millennium Copyright Act. They failed domestically because the issue was too controversial. So they went forum shopping and said, where can we get a deal? They went to the World Intellectual Property Organization and got a deal. And then they came back home and said, well, now there's an international treaty. We have to do it. Exact same thing is happening with trade secrets, but nobody else in the world has really caught on to this. So for the last several years, the United States has been undergoing a process of domestic reform of trade secrets law. And this is 21st century IP stuff. And it's the next frontier of IP because there is no international agreement other than, you know, a few provisions in TRIPS and the Paris Convention that does this. They say this is going to be the future, this is our new competitive advantage, and they use cyber espionage of, you know, Chinese companies stealing American trade secrets as the sort of poster child for this. Well, anyways, they put it in the international agreement. Now they're going to go back home. They're going to say, see, we have to enact this very controversial federal legislation. Now, what a country like Canada is going to do in response, I guess I don't know if I can ask you that, Laura, but it's going to be a huge constitutional problem because the last time we tried to create a federal action for unfair competition, the Supreme Court of Canada in the late 70s said it was unconstitutional. So that's where we are now.
Can I just jump in on that as well and bring in also the question of the one size, the all issues in one approach. I think what we're seeing, a number of provinces I think caught on to this time around, but not that many because there's still less of an understanding over what the provincial impact of. I think the provinces understand what the impact is of specific provisions, but they're not following it necessarily as closely. But what you're seeing is a lot of reservations from provinces on specific issues, and that's also how some specific subsets of domestic regulation get carved out of the large, the large cohesive, all-in approach. So you take the agreement as a whole, but at the negotiation stage you carve out A, B, and C. But then what you end up with is what Michael was talking about with the. And I think that'll get better when more awareness, like in the next trade agreement, provinces will maybe be more aware that this is a problem and they need to maybe get in there more aggressively early on or get reservations if they're worried about stuff like trade secrets law impacting the privacy policy. It's an imperfect solution though, using that type of, like carving out specific types of policies that just don't fit into the broader framework because of what Michael was talking about. What you get is, you get to keep what you have, but the standard, the long-term standard gets set at something lower. The minute we change our law again ever, we can't expand it to be more protected. Yeah. So the standard setting process. So that's how that's usually dealt with. The fact that it's this all-in-one approach, and the reason why it's adopted that way is because the infrastructure around it is going to be a cohesive enforcement infrastructure. But the problems of doing that way is that you still get locked into lower standards moving forward, and eventually they're going to win out, even if there are those types of carve-outs for specific types of policy.
Yeah, I want to mention the biotechnology protection, because we are talking about technology. So I think the biologics provision in the TPP, it's the most controversial. It was the most controversial provision during the negotiations, and the negotiations has been extended just because of the biologics provision and also some supply management issues of Canada and the New Zealand dairy. So and we were in Atlanta, I know, and we spent like how many nights, like until 4. They were like negotiating, and I was waiting outside with the farmer guys, like just to keeping eye on like the negotiators, because they were there and we had to be there. So, and when US first came up with this proposal on biologics, like that was the issue we raised. So biologics, biotechnology is a new field of technology. And we don't know much about it, we are still learning, and even with the patents, because the patent, the prior art in biotechnology, it's not huge, because we are still learning. The technology is developing, so the prior art is now like that. But in 5 years it will be like this, and 10 years it will be like that, and and we have challenges because. We had this U.S. Supreme Court decision from 2 years ago, which says that this is not patent eligible subject matter because, we are dealing with the natural products, and then it's more like a process patent. So we have, biologics are most of the cancer drugs that we use today are the biologics drugs. So the complex drugs which are based on living organisms. So it's different than the conventional pharmaceuticals. They are not small molecules, the chemicals, but they are the living organisms, and they offer better treatment with less side effect. So this is the next generation drugs, and pharma is in a rush to get this rule in the TPP because they know that there will be challenges with patents. So they wanted to introduce this alternative system. It's a kind of exclusivity, market exclusivity. Although they say that exclusivity is market exclusivity, when you provide the safety and efficacy data to marketing approval authority, you get some kind of exclusivity protection over that data. And in biologics, in biotechnology, different from the small molecules, a generic company need that data to produce the biosimilars, because they still need to produce some tests because we are relying on the living organism. So it's a very complex field of technology. We don't know much about that. And then there was this rush, 12 years. There should be protection in the TPP for 12 years because that was the US law, which has never been discussed in the US. It was part of the Obamacare package, and that was more like a bargain between the administration and the pharma. Agree on insurance, will give you 12 years, but then after a couple of years, the administration realized that what we did, 12 years is so long. So they came up in all the White House budgets, since 2009, it's 7 years. So that's what the administration, US administration wants to introduce 7 years because they think that 12 years is long. But then USTR Pharma was pushing from the day one that 12 years in the TPP. When US made the proposal, we knew that that was utopic because we know the country is like, and for example, Canada has 6+2, which is 8, or Japan has 8. And when these countries joined, they said that we are not going to change our patent laws. So it was between 8 and 5. And the discussions went on like until the very last minute. Like it was like 3 a.m., October 5, Australia and US made the deal. And then, you know, the other procedures, and then the press conference. So, and the ministers agreed to disagree. So there are like 2 options, 8 years and 5 years, because most of the countries have 5 years exclusivity, and some other measures. And now we are having a problem with the interpretation, because for me text is very clear. I know what negotiators were negotiating, what trade minister said at that time. They were all against 8 years. So it's like, it's not 5+3. It's like, my interpretation is 5+ set phase for pharma, because in reality, like there are always delays. So like the drug doesn't enter the market like within 5 years. But in order to know that, you need to know the technology. You need to know how biotechnology works. Our biologics, what is the marketing approval process for biologics? So these are the discussions we need to have. And for your question, coming back to your question on innovation, innovation is not prescriptive. You can't really come up with like one size fits all model, like, because every country has different realities, different priorities. So you can't really get a rule on innovation. But like in the TPP, we don't have a provision on technology transfer. I mean, it didn't work in TRIPS agreement, but it would have been nice to have like a provision on like some kind of technology transfer or knowledge transfer or something, if this is about 21st century and if we are living in knowledge economy. But of course, those are the issues we should have discussed, and we didn't have that discussion.
It was very interesting that one of the only times one of the US negotiators came to one of my presentations and moves, because we had like 7 minutes to present, and then they cut back to 3, and then we negotiated back to 7 minutes. But was when I was discussing.
Or 3 plus unhappy.
3 plus unhappy emoji. Please plus smiley emoji in this case, because we got back the 7 minutes. But it was actually on open innovation, and it was really interesting to hear from some of them that they are actually interested on innovation and allowing new ways for even their companies to collaborate with their users. And we have like consumer innovation and user innovation, whatever. But they just don't know those theories yet. Some of them don't know those theories yet. So it's very hard. And just to add to Bourgeois, that what's amazing, what happens here is that you have 20 years protection of patent. And then you have all the clinical trial data. That's not just about when you make a medicine, it's actually also when you are taking a medicine, what happens with you and how your disease progresses. So all that data would be then protected. And the point is you have 20 years, and then you have the 8 years or 12 years or 5 years, but in certain cases, right? So you are just extending, since you cannot extend your patent anymore, and then companies in India could provide generics for Brazil, like now companies in India cannot access that data to provide, not well in India still because they are not part of TPP yet, but there is this problem of innovating in generics because they cannot use the data to replicate the medicine. So.
I'm going to see if there's more comments in the audience, but I just want to pick up on a couple of comments that I'd like to hear more on as well. One is that it sounds like from the, I'm sensing pessimism. That this is supposed to be a 21st century agreement, and yet when there's rules related to 21st century things, the comment is that it's premature to have rules for those things, or we're using rules from the 19th century, so either rules are outdated or they're premature. And in any case, it's not appropriate to have rules for innovation. So that's one sense. So pick up on one question about what kind of research should be done then in order to, if you're going to talk about any framework for innovation? What's the kind of data that would be needed for that, for making some conclusions about that, since we're only coming up with negative conclusions? And I think that picks up again on the innovation point about, is there anything in the agreement then that does speak to innovation in a positive way? I don't know if we want to talk about those a little bit first to wrap up this.
I think one of the things that people were talking about was, so not, I'll redefine the question to include innovation plus rights enhancing, if I'm allowed to do that. And also somebody mentioned the question of whether doing a sector by sector cost benefit. So it may be too late to undertake that. I don't know.
There are some countries doing that. Malaysia is doing that cost benefit analysis, and it should be released.
And we got with Sonia's work and Brazilian bunch of people, we got an assessment from the human rights reporter, so we can mention that later too.
New Zealand too.
New Zealand as well. Or at least in the future, though, like I think it's useful to do like human rights impact analysis, innovation impact. Like innovation is difficult to measure by any, the regulatory impact of different regulatory mechanisms is difficult to measure. But there is some methodology. There's some you could do those types of impact assessments. Obviously, that's hard to do while also negotiating a 1,600-page 40-chapter, thing. But I think those types of mechanisms might be useful in the future.
Well, I don't like the measurements by patents and papers. I think that took us to the dark ages of universities and like by DOLAC and all this stuff. But on balanced language, right? We do have a much better language on exceptions and limitations. I don't know how Mike feels about that, but on the U.S. context, we do feel that when they say that each party shall endeavor to achieve an appropriate balance in its copyright and related systems that is consistent with the three-step test. And it seems a good language. One thing that starkly is bad if we are practical and not just reading the language is that interpretations of the three-step test are actually pretty bad. We have been fighting with the German Institute, the Max Planck, for a better interpretation, but that has not been the case for the policymakers. But the provision do lack any references to fair use or fair dealing. There is a lack of inclusions of snippets, data analysis, and other no expressive uses in the list of legitimate purposes. So it's very tricky when you bring a list to tell people what they can do if you're thinking on how technology works in the 21st century. So it brought some balance based on the previous language, but I think it's still flawed in some cases. So.
Can I just throw in really quickly? Also, opening up to other stakeholders more formally, I think would help as well, because that's where you get a lot of that dialogue coming in as well. So,
I was going to comment because there's a couple things quickly. First off, it's clear there are costs. I don't think anybody really knows many of the costs, and it's clear they haven't been well studied, right? So, so in this country we had promises from the prior government for large giveaways to dairy farmers, and I think it was $1 billion for the auto sector. Japan's talking about some support for some of their affected sectors. So it's like a very narrow slice with what seems like for them, I guess, to be a political winner at the time, although it turned out it wasn't, in terms of how to try to address the issue. For the most part, on almost all these issues, there have been nothing of that sort, right? So Howard just made a reference to New Zealand. So New Zealand did a cost study on what term extension would mean, and we can try to extrapolate the Canadian side. Then there will be those that say, well, the New Zealand study is flawed, and so it doesn't really give us a good number. But the point is, there have not been significant attempts to try to identify some of these costs and come back to the fact that we are talking about an enormous agreement. I mean, we're sitting here with 10 minutes left on this panel, and we had a long list of stuff that we thought we were going to do deep dives into, and it turns out we're not going to do deep dives into practically any of those things because there's just so much to talk about that you can't do it in an hour and a half, it turns out. I mean, I don't think you...
Learn by the experience.
The question we're going to face is, can you do it in 2 years? Because what we are going to face
or
is...
a yes and no vote in the American Congress.
Yeah, well, from a Canadian perspective, we're going to... We, for all intents and purposes, will sign alongside all the other TPP countries in early February, and there's an argument to be made that makes sense, that there are benefits of being an original signatory, and if you are not part of that, then you don't count for other purposes within the treaty. And so even if you don't know if you're necessarily going to ultimately ratify the treaty and implement it, it still is the case that signing may make sense. There's an argument, and so my suspicion is the government will say it makes sense to at least keep ourselves in the game. That was why we got into this in the first place. To walk away now undermines at least our ability to be at the front of the line if we choose to move forward with it. But what's important is, I think that it's critical that the government recognize that this has not been well studied, that it has been conducted from a negotiation perspective, as we've heard, almost entirely in secret, which is undoubtedly going to lead to all sorts of unintended consequences. We had one even in the notice and notice provision that I made reference to earlier, where the provision that was designed to allow Canada to keep its notice and notice could be interpreted in a manner that actually wouldn't have allowed us to keep it, because there was some language missing. And between Atlanta on the one hand and the text being released a month later, they made a slight change that tried to address the issue. My question would be, how many other instances are there where there are similar kinds of things? There were even reports in the last week that the U.S. is using what's known as the legal scrubbing process right now to make some changes within some of the IP provisions before they actually signed in February. So that tells me, A, there is still room to make changes. To Howard's question, is there room? Well, the U.S. is trying to make changes, and if they're trying to make some changes, then surely it's open to others. But even more fundamentally, it also tells me that we just don't know enough to know whether or not this makes any sense. And what we really need is a government that says, even if we sign, because it makes sense for us to sign here, we make a real, genuine commitment to do detailed studies and economic analysis and public participation in all of this, so that we ultimately make a Canadian choice. And it might be that we choose to say, you know what, this does benefit, and we are going to do it, notwithstanding some of the costs. But at the moment, we're left with an agreement that practically no one has read in its entirety. Nobody, for the most part, was even aware of what was in there at a true legal level, because it was all conducted in secret. And we're hearing from some, well, of course you ought to sign it, go ahead. No, what we really need to do is say, we've got at least a couple of years to do the kind of study that you referenced, and we need to go ahead and do it.
Yeah, I mean, adding up on that, like every time I talk to the negotiators, like including Boris, they were telling me that like signing an FTA is one story, implementing it another story. So like someone asked a question and asked whether this was an end. This is not the end. This is just the beginning of the end. So like, you know.
Which is less pessimistic.
Yeah.
I think we are global English speakers, so you guys think that.
So it's like, we are there. We are okay. We have the text. The text is concluded, but the side letter process is still going on. And like I mean, when I showed you the photo, that was the text of the agreement, excluding the side letters. So we don't know, like some of the side letters are available there, but still the negotiations are going on for the side letters. And from our own experiences, we know that like the side letters change certain provisions. And this ISP liability issue is quite interesting, because TPP will be a living agreement. That's what USTR has been telling. That's the 21st century high standard agreement, and more countries will join. And we know from the WTO accession process, when countries join, they go beyond the existing rules. So the TPP will be the minimum standard. It's not the maximum. Maybe for the existing countries who negotiated the TPP, there are some flexibilities there. But the countries who will access later on, there are really serious issues. That's why we need a better research. We need to understand those provisions very well, and we need to come up with like a better implementation models. Like because. And yes, like as Jeremy said, ambiguity leads to fallacy. So like it's important that we know what is in that provision and how it can be best implemented. And I think as legal scholars, that's our responsibility now to come up with a better implementation models, because that's why that's the only way we can assure that the 21st century, that these 20th century rules work for 21st century.
Yep. I think just on the evidence issue, we need to do better a job as academics translating the vast body of empirical research that exists into practice, putting that in the hands of policymakers. The Hargraves report, I think, is the best example of a categorical rejection of lobbynomics. And perhaps there's no better example in the TPP than copyright term extension, which I don't even know if we've mentioned on this panel yet, but it's the most sort of economically ludicrous thing to do. But interestingly, for a lot of this, from a Canadian perspective, there actually won't be that many big changes in the law. The small changes there are going to have big impacts. But in a way, it's because we've already been laying the groundwork for this agreement for a decade. And basically, so look at trademarks, for example. The trademark provisions in the TPP are radically different from what Canada has currently. But it's not going to require a big change in the law because we're already changing to comply with CETA. And so now when we say, well, we've got to have there's international pressure to align our laws to some new framework, and then you start to do it in a piecemeal fashion, and you say, well, look, it's no big deal because we've already done it. It's a very, very dangerous circular logic that makes impact assessment on a holistic basis very difficult.
And if I can add a little bit to that, but also from the telco chapter, that was something that was asked on also. So 2 points. One thing I think is innovation for who, right? And because that's, I think it's a big question, and the telco gives us one of the answers. Unfortunately, it's for the big telcos in US, in the case of the telco chapter, because they do require, one, that a major telco regulator exists in that country, so a bunch of countries already have it. The US have the FCC, but a bunch of the developing countries involved, I think Vietnam, a couple of them, they don't have that regulatory agency. So there's going to be a lot of cost and process organizing that. I'm actually pro-institution, I'm a pro-institution person, but we have to understand what that costs for that country. And also, and on the telco chapter, it asks, must make interconnection available on just and reasonable terms, provide access to leased circuits for essential facilities at commercial reasonable terms, which that means actually special access. So what's giving is AT&T and Verizon and all the big multinationals that are US at the end, some form of preferential access to small countries' markets. So they cannot protect their small or innovative telcos or ISPs because they're gonna have to give access as fast as they can for the big telcos. And the big telcos have more resources, have more infrastructure, they have their international value chain already organized. So it's just a matter of a tractor coming to your country. So it depends on innovation for whom, right, in some cases.
There are some good things like net neutrality rules that are generally
not mandatory though.
Mentioned in there that are help innovation, just to not completely end on a doom and gloom. However, they're not very strong.
So I'm sorry to say I think we only have a couple of minutes left, so I don't know if we have time for any more questions, but I just wanted to say.
Oh, and I forgot to say sorry for that. They were really, because everybody asked about that. There is a provision in the TPP saying that people, all of us, should participate in the implementation process through consultation. So all the regulation is not mandatory, but you guys can ask that. Like you can participate in the implementation. There is a suggested consultation process through implementation. So keep an eye on that and get involved.
I'm not familiar with that provision.
well, like now they say.
Yeah.
Here's what we did.
I agree.
Just fix it.
I agree. But still, it's there.
As you can see, there's still a lot to talk about, and I think, as Michael said, we've barely scratched the surface, so I would invite the organizers to think about having a follow-up.
Mari now announces his retirement.
3 days conference on the TPP.
Yes, it's probably more the scale that might be needed to really get into the issues, because obviously even just picking one theme, lots of things come to the surface, repressed things and other things. Anyway, so I just want to thank everyone on the panel first for first putting it together and also participating in this discussion, and hopefully everyone has a little bit better sense of at least some of the issues involved that will require more study that we can all go off and think some more about. I'd like to thank everybody here for coming to hear about these issues and to and to ask some of the questions that form the basis for this. I think it's been very helpful for me, and I think for everyone to, as I said at the beginning, enrich their understanding of what's involved in this, on this theme, but more broadly in terms of the agreement as a whole. So I don't know if the host want to say
Yeah, can I add something? I have to mention that, not because Loris is here, but I've been following the TPP very closely, and I've been talking to all the negotiators. And I have to say that, like, you know, these guys, they were amazing, you know, like, I mean, the IP negotiators, they worked really hard, and to make that text better, and like, they were like very responsive. I know what they could do was limited, but still, I think they deserve a big acknowledgement for
I'll
their
add that
time
as
and
much as we've
effort.
been down on the innovation and everything,
Yeah.
it is better than it was when it started by significant.
So we owe a huge thanks to all the TPP negotiators, excluding USTR. We like them, but like.
Sorry,
No,